Namaskar viewers, hello and welcome to Sunset TV. I am Tina Jha. You're watching Perspective, where today we will be talking about the Criminal Procedure Identification Bill 2022. Passed by the Parliament this week, the bill seeks to repeal the Identification of Prisoners Act 1920 and expands the scope of information the government can collect from convicts, arrested persons and other persons such as the habitual offenders. Now, according to Union Home Minister Amit Shah, the sole objective of the legislation is to improve the conviction rate in the country, protect the human rights of crores of law-abiding citizens, and also send across a strong message in society. But the opposition members, on the other hand, claim the legislation is violative of fundamental rights and infringes upon individual freedom and privacy. How valid are these concerns? What checks and balances does this proposed law provide to prevent misuse? And also, how effective will it be in strengthening our criminal justice system? To share their perspectives on these aspects and much more, also on the Criminal Procedure Identification Bill, I'm joined on the show by three distinguished panelists. So let me first introduce them to you. With me in the studio is Mr. Sangram Patnaik, Advocate Supreme Court, and Mr. Shyam Suman, Legal Editor, Hindustan. Thank you, gentlemen, for joining me on the program today. And also joining us virtually is Dr. Vikram Singh, former DGP, Uttar Pradesh. Thank you, Dr. Singh, for joining us on this edition of Perspective on Sunset TV. In fact, let me begin the program today with you because a lot of powers will be given to the police now, according to this proposed legislation. Help us and our viewers understand what are the extra powers that the police is going to get if this proposed legislation comes into effect, and how different is it from the law which is at the moment existing?
It is my proud privilege to say that this will be nothing short of a revolution in criminal jurisprudence and investigation work. What worked yesterday will not work today. A small beginning was made in 1980 when the Law Commission made a recommendation on these lines. And in the year 2003, the Malibath Commission also echoed the same sentiments. What has changed is that from the year 1920, Prisoners Identification Act became redundant, say by about 1950. Since 1950 till this, almost for 75 years, we have had a system that was anachronistic and was not equal to the task of getting after the underworld, the crime syndicates, the mafia, and those who were charged of heinous crime. Now, this Criminal Procedure Identification Bill, I'm sure, will address this lacuna, the gaping holes, and the horrible fault lines. How? You see, the criminals are smart. The underworld is smart. I have known so many cases where they would use plastic surgery to remove and obliterate fingerprints, use facial recognition, remove them. And that is not to mention that the biometric systems also would and can also be in a manner concealed. I don't say changed, concealed and camouflaged. Now, the problem arises that with this criminal identification bill, these addressed things will be added. But yes, there will be criticism, the fundamental rights, etc. But these criticisms have no meaning. We have illustrious panelists who will explain
Absolutely.
that no
we'll get into the
rights,
criticisms, the concerns which we've heard the opposition members raise in both houses of parliament during the debate in Lok Sabha as well as Rajya Sabha. But before that, let me go across to Mr. Patnaik and understand his point of view. Do you agree with Dr. Singh that it is a significant step which is going to revolutionize the criminal jurisprudence in our country?
See, I would start by saying yes in emphatic terms. One. Second, which is the most important thing, we always talk about the fundamental rights of the people who are, going to be convicted or the person who are accused. We never encourage that other aspect of law. Where is the fundamental right of the person who is actually the sufferer?
Yes.
Right? The complainants. Where do they go? Where is the fundamental right of those people? So I personally believe, the person who obeys the law, he feels cheated the moment you recognize only the right of a person who has made these crimes, right? So according to me, you cannot brush aside and you cannot put everything under the carpet by saying yes under the banner, so-called banner of fundamental right, 14, 21, 19, which all of us know, the constitutional provision is there. But that doesn't mean, what is it about? It is a scientific treatment of a person that yes, he is to be convicted. So these are the methods, right? For example, that you would say that swab, you would say the retina testing. All those things would put in a scientific manner that this person needs to be convicted. So what is the harm in it? Now, you would say that no, there is a fundamental right which has been violated. Second, you would say no, there is a right to information act, and you are violating somebody's privacy. All said and done, if a person is convicted because of the scientific evidences, probably hats up to this legislation, people would salute for the generation to come, particularly for the reason there are a number of people who are being scot-free only because of the two provisions that no, you would not do this, you would not do that. But the moment the provision is there and that is a statutory backup is there, so according to me, it would be path-breaking, no doubt about it, and it would be a step in the direct direction that tomorrow people would think twice to do any crime. That's my first and fundamental objective.
Okay, Mr. Suman, do you think it's going to be acting as a deterrence, which the government thinks it is going to? But what are the concerns which the opposition parties have raised, and why are these concerns emanating? How is it violating the fundamental rights of people?
Yes, the moment this bill will come out and become a law, it will be challenged in the Supreme Court, and I hope the Supreme Court will look into it, the nitty-gritty of the things, and I think the bill, let first pass the bill, then we'll discuss it.
Okay, so since you mentioned it is going to be challenged in Coast of Patnaik, do you think it is going to stand ground? Does it have so many advantages that it is going to stand ground in the top court?
See, I will tell you what. Like, after, in the US, this law was there since last 20 years. In UK, it is 2012. Now, for example, there is a swab test, or you are taking the photograph, you are having, earlier it was fingerprints, right, or footprints. If there is a additional evidence is to be required to prove somebody guilty, whose fundamental right we are talking about? So it is actually, we are protecting a person. Suppose, for example, that the person is a criminal, he has not done it. It would be an additional scientific evidence. So if I would to say, in a general parlance, people would say fundamental right of this person is affected, that person. Let us put it in a waste paper basket for a moment. Let us discuss and debate that whether the fundamental right of this person is also not being affected because he has given twice the chance of proving that he is not guilty. In the sense, suppose this test, these 3 tests which has been added, suppose that is a swab test, it is not been proven. Now, he would be scot-free. So, how is it affecting the right of that person that yes, all these additional scientific evidences would affect only the person who has done this crime? See, according to me, that should be a balance. We are talking too much about the fundamental right of a criminal rather than a fundamental right of a complainant. I am not generalizing the things. In legal parlance, we as a lawyer, I am not saying that as a community as a lawyer, but we as a lawyer have a right to defend a person who is your client, right? No difficulty. Now, today, if I have to appear for the complainant or for the prosecution point of view, why these evidences are not valid? Why these evidences are not taken into the record? I would not say that Supreme Court would not judge this issue. Of course, Supreme Court is the final authority. You declare law, whether it is valid or not valid. But suppose Supreme Court is going to reject, so therefore we will not bring this bill. I think there is something which we are lacking. Now, secondly, which is the most important thing according to me, today we are debating about this issue that yes, this bill has come. Now, Dr. Singh is absolutely correct that every society, right, requires a law which is fit into that scheme of thing of that present moment and present era. Today, if this law has come or would to become, for example, if it has come, whose benefit it is? Our society's requirement is this, because the age-old law has no value and meaning. Someday, in some time in your life, you would say this is enough. Let us have a law which is actually the need of hour. The need of hour is this law. And the moment you have this robust system, criminal jurisprudence, which would prove and doubly sure that this person needs to be convicted, and probably we are looking for that day.
Okay. Very important point, Dr. Singh. Of course, makes a lot of sense to repeal a 102-year-old law. We are updating as per the changing times, and technology is very, very important. So basically, to make our police system, our criminal justice system tech-savvy as per the changing technology is the need of the hour. But at the same time, does the proposed legislation ensure that it is not misused? Because a lot of criticism, a lot of concern which has been raised by opposition parties in both houses is that it lacks the right checks and balances.
Words of profound wisdom from the earlier esteemed panelists, and I agree with him in toto. Now coming to the fact that yes, this is not being run by a police station. It will be in the governance and the superintendence of the NCRB and other senior officers. Any new legislation is bound to have certain roadblocks and hiccups. But having said that, proper training, proper policing, proper supervision will ensure that there is very little scope for manipulation. But look at the advantage and the win-win situation. Lesser amount of third degree, lesser amount of complaints of police high-handedness, lesser amount of fudging in the investigation, and greater number of conviction. And as the earlier esteemed panelists mentioned, that it is obviously a person, that it is incontrovertible evidence that is being produced. Therefore, if the person is innocent, that will also stand in good stead. But any new legislation is bound to have such things. But in the policing, you see, all the thing is, in this case, is being done by a head constable or a superior officer. But the whole chain of supervisory officer, beginning from the station house officer to the ACP, to the DCP, to the police commissioner, everybody would be monitoring faithfully the various important clauses of this legislation. Therefore, I per se would not feel that there is even a scope of any manipulation, but it has to be made foolproof and fail-proof. And the ecosystem of security that this statute will generate obviously has a tremendous fallout, and the citizens need to know that yes, the checks and balances have been appropriately addressed. There is proper policing and supervision to ensure that the ground level working is absolutely transparent and error-free.
Certainly. So if that happens, of course, the criticism should die down. But Mr. Suman, one concern that I've been hearing since the debate began on this bill is that because the ambit has been expanded, it could also affect the common citizens, even those who are not convicted of serious crimes, even those who have been detained for minor offences. Yes. Could this be a problem area for the common man going forth?
Yes, of course. The first thing I would like to point out is we don't have in India a data protection law. This huge data will be collected through the police stations, and as Dr. Singh said, a head constable will collect that data, and that data will be put in the depository of the NCRB for the 75 years. And still we don't have the data protection law. Data protection law last 2-3 years back was conceived, and that protection law bill is, I think, before the Joint Parliamentary Committee. So my point is, if we don't have a data protection law and we are going to collect a huge mega billions of bytes of data, and Dr. Singh said that chances of manipulation are there.
Absolutely. I think, Mr. Patnaik, that is a very valid concern. Correct. On data protection, even though the government will say that we will have a technology-driven, foolproof mechanism to ensure there is no data leakage, but so far our experience hasn't been good. We've seen that in case of Aadhaar data. We've seen also that in case of social media accounts, how personal details of individuals have been leaked out. So the biggest challenge will be to ensure the data of so many people, be it the hardcore convicts, even those who are detained for minor crimes, is not leaked.
Before Mr. Patnaik, I just want to add one more thing. The thing is, when the police station, suppose some investigation is going on, and police station and the police investigating officer wants to verify some data, and I was hearing Home Minister was replying to your question, when police officer will ask to verify the data, it will go to the NCRB. NCRB will give the result only. How they will make it sure that the only result will be given to the investigating officer, not the whole thing? That is my point.
Okay,
that is my concern.
I have a different take. With great respect to my friend, you don't throw the baby with the bath water. The plain simple two reasons. If there is a data available, for whose benefit it is? Society's benefit. Suppose there is a criminal, right? And everybody does, all developed countries. Mind it, it's not our country, because our country we started off. I mean, we woken up after such long years. Now in US, suppose there is a data available, and you can straight tick that, you can verify the background of that person, where he has come from, whose father, mother, DNA, everything is available. Just click of the mouse. Now, if that is there are two reasons why it should be. One, that would be less crime. You can recognize that criminal straight away, whether it is here in this country or he is traveling abroad. So that is one benefit of it. Second, you could reduce the crime. The net impact would be what? That I'm available in a domain where anybody can access. So therefore, I would not do it. That is the deterrence. So if somebody asks that, no, let us do away with because that would be a theft in the data protection, I would respectfully submit. Let us have a data protection bill passed, there is no difficulty. But you cannot throw the baby with the bathwater because that bathwater is nasty, so therefore you throw the baby. It is a brainchild of a long years which we have waited for. Now suppose, for example, it has come into the picture and come to the daylight. Now whose benefit is the society would get that? Suppose I could able to know that the person who is staying in my neighborhood is a criminal or the data is available. You are not searching for years together that why there is a lack of evidence. The court would say, all the the lower courts, the courts, they would say you have no evidences. You cannot convict with this kind of evidences. It is only the addition. If it is available in the NCRB record and you could able to get it with a click of the mouse, it will reduce your time first. Second, that it will be pinpointing that person that yes, this is the credential of the person. So I would suggest if there is a lacuna or the loopholes in the data protection bill, you protect that, you block that. But don't say that it is because of this bill or because of this act is not into picture, so therefore you throw this act. With great respect, I have a different take on it.
Okay, but there are concerns which, of course, the Home Minister has tried to address. In the times to come, how actually these happen on the ground, how the law is implemented is something that all of us will have to see. But Mr. Singh, coming back to you, in a system where, we are seeing the police also misusing a lot of the powers, and herein we are giving them some extraordinary, unprecedented powers, how will we ensure that it's not misused, the common man doesn't end up being harassed? And in our system where we go by the principle that no innocent is punished without proper, hearing, without proper justice, and that explains the long delays in our judicial system as well. So to ensure that no innocent is harassed, no common man has to suffer, of course, it's a good objective. It will reduce crimes. But of course, also, we can't be overlooking the common man's concern.
Tinaji, I'll try to encompass what has happened in the last 65 years. You first see that this is scientific algorithm, and it's very difficult to fudge the data that has been collected very, very carefully. Under these circumstances, we have inherited a system of writing the case diaries where there was so much of authority and discretion with the IO. And it dates back to 1861 in Urdu. Now it was translated into Devanagari. Mauka Moina, Naksha Nazari, Nakal Chik, Nakal Rafat, Bayan Chashmadid Gawahan, Bayan Samai Shahadat. Just translated into English would mean testimony of the eyewitness, testimony of the oral witness, inspection of the site, and incorporation of the FIR. And there is so much of manipulation that is possible in the traditional standards, which is not possible here because it is from the database. Then we must also understand that it is akin to a digital history sheet or a digital Janam Patri. Therefore, it is very difficult to fudge the data. And as our esteemed panelists have agreed, it is a scientific innovation. Like any new statute, a scientific innovation, a new introduction, there will always have to be the development and also reinforcements of law so that it becomes fail-proof during its use. Obviously, there may be chances of some revolutionary person trying to misuse, but I feel the chances will win because the evidence produced will not be oral or what is written in the case diary. It is scientific evidence, scientifically collected, scientifically collated, and scientifically produced. Therefore, the scope of manipulation and corruption are absolutely minimal. I do hope my learned panelists will also give their thoughts on this because I personally feel that it is a new dimension to investigation policing, which will be beneficial to the country and to everybody.
Okay, Mr. Suman, coming back to you, new dimension to investigative policing, which is going to strengthen our criminal justice system. Yeah. But, if we compare it to the existing law, do you think the new law, which has been passed by both houses, lacks some of the safeguards? And in our country, we have to also speak of the fact that implementation faces the most hurdles. So the law on paper is something else, but when the rules are framed, and also because police is a state subject, it is going to differ from state to state?
Yes. Let me say one thing. The safeguard, as far as safeguard is concerned, one safeguard which I found very missing is that if I have committed some offense, an offense doesn't carry very big sentence or long sentence. Suppose my offense carries only 6 months sentence, but all my biometrics, everything will be collected by the Havaldar. After and even if my case goes to the court and court says no, nothing happened, you are a free man, no evidence against me, then what will happen?
I think I heard the similar story that, you know,
That data will remain. Okay, there is a safeguard. This data, if I have acquitted of all the things.
Is there,
the data will be
Mr. Patnaik,
deleted.
is there no period specified for which the data will be stored in the system? And also the concern
No,
that Mr.
there is a
Suman
limit.
pointed-
Let me explain. There is a limit. If I got scot free or if I am acquitted in the case, then data will be deleted. Fine,
Yes.
fair enough. But for the 6 months punishment, a small traffic offence, I am being hauled up and my all biometric have been collected. What is the use of that? The
Okay,
first thing.
okay.
Second thing, Constitution provides us one cannot enforce me to self-incriminate myself. But here, if I am caught, there is no evidence. But so the first time police comes, no, you give all the data, and I will have to give to you. If I don't give, then they will again haul me up.
Coercion.
Coercion. 188, section 188 will come into force, and then will again. There is no safeguard. I think the safeguard must be there.
Dr. Singh, this brings me to the question, what explains, you know, the expansion of the ambit in a way in the new legislation that also brings into, you know, the ambit the people who have been detained for minor crimes. So, for example, as Mr. Suman pointed out, for a minor traffic offence, and even that person has to give all of these details, the biometrics, and if the police deems right, the other kinds of details as well. Can it not be just restricted to those who are convicted or arrested for crimes, for serious crimes? Yes.
Tina ji, Mr. Suman has a very valid concern, and I feel that it's shared by everyone. Now, let me tell you, what to talk of minor offences, even in preventive cases, preventive action, preventive detention, also these samples are mandatorily to be collected. Now, it is debatable whether it is desirable, whether it's legal. I would say that what is said that one has to cooperate with the investigation and not to cooperate with the investigation. What to talk of the other side of the coin is self-incriminating doctrine. As a ex-police officer, I would say that yes, you have to cooperate with the investigation. If you don't, well, there will be consequences. Now, even in the current level of policing, there are multiple levels of checks and balances. Like first, there is active list for very petty and minor matters. Then there are several registered at the police station in which the data and the modus operandi are incorporated. Then finally, if a person figures in any crime, whether convicted or acquitted, there is a history sheet which is closed and destroyed only after the death. So therefore, this is digitized form of history sheeting. And yes, the concern, Mr. Suman, is that if I am accused only of a traffic violation or a preventive action, I think it is too harsh a measure under these circumstances. Well, let the nation debate, because the law and order concerns are such, perhaps a database would be necessary. In any case, this was being done as a hard copy in active list, wanted list, as a Kriyashil Aparadhi register, and such. I would not like to go into the nomenclature of other documents in the police station, but this practice is already there. And I would like to inform the learned panelists that it is only in the electronic form that we are doing it now, Tina ji.
Okay, Mr. Patnaik, one last comment from you on how do you look at the future? The bill has been passed by both houses. It is going to face some legal challenge, as we hear and as we, since the debate has started in both houses. We've spoken to a lot of legal experts as well, and it looks like it is going to be taken to the Supreme Court. So how do you look at the future? And if we talk about the implementation as well, what kinds of checks and balances do you think are necessary before the rules are framed for its implementation?
See, discuss and debate are two parametria of any robust democracy, no doubt about it. I'm not saying A is wrong or B is wrong, but don't look at one point of view. Second, every state in this bill itself has given the power, because like you rightly said, that it is a state subject. Now they can frame their own respective rules, right? And Mr. Singh is absolutely correct when he said that it is only digitizing that whatever the evidences you have and in a electronic form. Now, suppose, for example, one would say that, yes, do you really believe that because of, plugging the holes, we should throw that entire aspect of law to a dustbin and saying that, no, this is not a good law? I'm sorry. With regard to, yes, data protection, I'm absolutely in agreement that it has to be debated. it has to be agreed upon that these are the parameters which we should take care of before implementing, before notifying this act in the parliament. After the bill is passed, it has to be notified. So all those things should come. And prior to that also, there should be rules, right? Every state is entitled to have the rules. There is no difficulty. But why I'm saying we are going to be mature democracy, because we are only respecting the right of a criminal or a petty criminal, notwithstanding the fact that there is also a right vis-a-vis of another citizen. Now today, if I have to say that yes, I have to hold a brief, that I would say yes, there are two things wrong in this bill, might be wrong, but I'm not a legislator or a parliamentarian to debate upon, but there is certainly an aspect which is to be notified and appreciated if it has been done after such a long years. Number two, if there is something lacking, for example, fundamental right of ABCD, you give them that such an opportunity. Like you said that yes, there is a petty crime, your traffic violation is there. It is not that it is remaining there for 75 years. You are a hardcore criminal. Not so. Suppose you are being acquitted, right? So your slate is clean. Now to say that I should not be given any, that is a debatable point.
And in fact, I was reading somewhere that Yasin Bhatkal for the first time was caught in Kolkata for a petty crime back in 2009. And it's just later on in the years when he was released that it was found that he, turned out to be such a big criminal. So that could be one advantage, Mr. Suman. Let's see how it's implemented, how the rules are framed. For now, the bill has been passed by both houses of parliament. The implementation will be the challenge, how the rules are going to be framed. So there are lots of merits, certain valid concerns which have been flagged off by opposition members. We've discussed them on our panel as well with the distinguished panelists. So how these are addressed is something that we'll all have to wait and watch. But for the moment, as two of our panelists suggested, it's a very, very significant step which is going to reduce crimes and also bring us the second part of the story. We always talk about the fundamental rights, the human rights violations of the accused. Now it also takes into account the story of those who have suffered. So not just violations of the accused, but also the ones who have suffered for so many years, who keep going to the courts, but their hearings are only delayed. And I think this is the trust that will be built in our justice system if this particular law is implemented in full effect after all these concerns are addressed. So I think with that, I'll have to wrap up the discussion today. Thank you to all of you for joining me on the program today, sharing your thoughts, your perspective with us and our viewers. So that's it from us on this edition of Perspective Today. Thanks very much to all our viewers as well for their time. See you again next time.